Morning, everybody. Thank you so much for coming to join us on our second festive Deka case update. And I'm delighted to say that we've got some great panelists today, as well as myself, of course. We're starting with Amelia Katz, who's giving an update on police law. And then we'll be handing over to Ed, who's going to be talking about court of protection. Then Esther, clinical negligence, myself on travel, and then we're finishing up with John, who's going to be talking about personal injury. And before we get started, just a couple of housekeeping things. Please do ask questions. The best way to do that is to use the Q&A function, which hopefully you can see on your screen. And we will try and see if we can deal with questions as we're going along. But if we don't have time to get to your question, we'll try and deal with it at the end, or otherwise we can follow things up on email afterwards. So please do ask questions. Do feel free to use the chat as well. If you put something in the chat, we won't necessarily answer it. So Q&A is the best thing for questions. Chat's the best thing for general chat. You know, I have to say, we're all feeling very festive here at Deka Towers. We've got snow that we can see outside the window. We've got Christmas jumpers. We've struggled through ice, snow, and train strikes, or alternatively, brave the stairs at home to get up to the study in order to be with you today. So thank you very much for joining us. And without further ado, we'll start with Amelia, who I'll hand over to.
Afternoon, everyone. I'm Amelia. I am one of the juniors in Chambers. I practice across all of Chambers areas, but I do have a fairly significant police law practice. So I'll just be providing a fairly brief update on some important cases that have come through. I'm going to focus on actions against the police. A lot of both the cases I'm going to focus on will be applicable to other claims against public authorities as well. And then at the end, I'll just briefly note a couple of other decisions that have been of some importance this year. So starting with the first case, and if I could have the next slide, this is the case of Tyndall and Thames Valley Police, heard in the Court of Appeal. This case, Andrew Warnock from Chambers represented the police in the appeal. And it is an extremely important case because it kind of puts a full stop on the flux, the state of the law that was very much in flux before this case, as to the responsibilities of public authorities. The facts of this case are that in 2014, a motorist, Mr. K, was driving along the A413 in Buckinghamshire. He skidded on black ice and lost control of his vehicle and crashed. Despite being injured, he called the emergency services. He told them that there was black ice on the road and that it was causing a danger to motorists. The call was then taken by a police control room operator. And while he was waiting for people to attend, he sought to alert other road users to the danger posed by the ice. The police then attended the scene. They put up a temporary slow sign by the carriageway while they were there. They cleared away the debris from the crash, and Mr. K was put in the care of the ambulance service. Once he'd been removed to hospital, they left the scene and they took their sign with them. They didn't take any action to remove the black ice, nor did they leave the warning that they had put in place or put any other kind of warning in place for motorists. If we go to the next slide, then later in the day, not very much later, only 20 minutes, another accident occurred on the same stretch of road for the same reasons. And another driver collided with the car that was driven by Mr. Tyndall. Tragically, both drivers died in the accident, and Mr. Tyndall's widow brought a claim in negligence against both the police and the highway authority. In relation to the police, the allegations of breach against them were that it made the danger worse. For two reasons. Firstly, that because they had attended, Mr. K, who had been making efforts to warn vehicles about the danger, had then stopped as a result. And secondly, that they hadn't taken any proper steps to protect motorists who were using the road. It was also contended by the claimants that the police had assumed responsibility for their actions in the circumstances, and there was an application by the police to strike out the claim. If we could go to the next slide, at first instance, the application for strikeout was unsuccessful. The master concluded that the claim had real prospect of success, setting out that the officers had removed a warning sign after they put it up, and they took minimal steps to render the road safe. She also noted that they had themselves arranged Mr. K's removal from the scene, which caused his efforts to warn traffic to cease, and that the matters could in principle amount to sufficient intervention that the police had made matters worse. The master also noted that the law in this area was in a state of flux, and factored that into her decision to disallow the strikeout application. The police appealed to the Court of Appeal, and the Court of Appeal allowed the appeal and struck out the case. And if we go to the next slide, we can see that they set out a very useful summary of the principles applying to the liability of public authorities at paragraph 54 of their judgment. There are 9 of them. I'm not going to set them all out for the purposes of this update, but there are 2 key points that arise out of this. The first is that merely allowing a pre-existing danger to continue cannot amount to the creation of a danger. So any claim in this area needs to focus on the factors that indicate the situation has been made worse by the relevant public authority. In this case, the fact that they hadn't taken any steps to alleviate the black ice or to warn anyone meant that the danger simply continued. They hadn't created the danger. The second principle is as I was saying before, that there's no longer this situation where the law is in flux. The principles are settled. They've now been authoritatively summarized. So there's now little scope for claimants to resist applications to strike out on the basis that this is a developing area of law. So this is a really, really key update from this year in the area of liability for public authorities. The second case we're going to look at in a bit more depth is AB and Chief Constable of British Transport Police. This is a High Court case, and it follows on from a Court of Appeal case earlier on in the year that we'll look at briefly at the end. The reason I think we should focus on this one is because it shows how the court will approach data protection claims, which is an area that's growing rapidly, particularly against the police. There's been a real uptick in claims against the police by people who have been investigated or charged and convicted with crimes for how the police have recorded their investigations, or in some cases shared the results of investigations. And so this is a useful case to look at in how the courts approach these types of claims. In this case, the respondent had autistic spectrum disorder. That is AB, who was the claimant. He suffered from high levels of anxiety and communication and processing difficulties. And one of his coping mechanisms was that he stimmed or ticked, and he would rub fabric between his fingers. There were 2 complaints made against him to the police that he had touched women on public transport inappropriately, one in 2011 and one in 2014. There was an investigation, and he wasn't charged with any offence, but the police retained the information about the complaints. If we could have the next slide. The claimant wished for the, I don't know if the next slide is up there now, but I'll continue. The claimant brought a claim contending that the retention of the information was unlawful because it was inaccurate and it was disproportionate interference with his right to respect for private life under Article 8. The judge found at first instance that the details recorded reflected what the police had been told, but they weren't an accurate account of what had actually happened. He also found that the claimant hadn't actually posed any real risk to the complainant, and that his disability diminished the risk he posed generally. He concluded that the retention of the records did amount to a breach of Article 8 of the Convention, and ordered that police delete the records. He then made an award of damages for 15,000 in respect of loss of earnings, a further award of 15,000 for distress, and a further 6,000 for aggravated damages. So not insignificant awards, particularly in the context of a data protection claim. The police appealed the decision, and they contended that the judge had erred in finding that the records were inaccurate and in finding that there had been a disproportionate interference. The High Court concluded that the judge had been entitled to assess the underlying merits of the records and the risk that AB posed. Now, what's quite interesting in the judgment of the High Court is there's reference made to the fact that if the case was being determined again at first instance, the decision may well have been different. However, that didn't detract from the fact that in their view, the trial judge was nevertheless entitled to draw the conclusions that he did. And it's also important to note that this was very much a case-specific decision. It was about the severe distress that the claimant had suffered, and the fact that he didn't present any real risk to the public. In most cases, there will be a public interest in retaining records, and it was only the balance in this case that led to the court reaching the conclusion that it did. So just finally to look at very briefly a couple of other decisions that have come out. The first is Wisey and Chief Constable. This is the case that preceded AB, which we've just looked at in the Court of Appeal, and it was distinguished in AB. Similar facts, the claimant had sought deletion of data relating to his acquittal for 3 counts of rape. However, in that case, the Court of Appeal concluded there was justification for retaining the data for safeguarding purposes. And so YZ's claim was dismissed. There's also been Lee and Metropolitan Police Commissioner, which was a judicial review following the policing of the vigil for Sarah Everard. The JR was allowed and the decisions of the police were criticised in how that was policed. And finally, ST and Chief Constable of Nottinghamshire Police. This was a claim for false imprisonment following the arrest of a 14-year-old at 5:30 a.m. following pretty spurious accusations he'd stolen a phone from another student at his school. The claim was dismissed at first instance, but that was overturned on appeal, and the arrest was found to be unnecessary and unlawful, and the claim made out. So that is my update. I'll hand over now, and if there are any questions, put them in the chat, and we can try and get to them at the end.
Thanks very much, Amelia. Well, I'm going to hand you over to Ed Lamb now to talk about Court of Protection.
Hi, everyone. Good afternoon. This is a light sherry between the main clarets of the other speakers. I saw on the list that there aren't any specific Court of Protection specialist practitioners here. I am constantly banging the drum that us as civil practitioners, both claimant and defendant, are increasingly exposed to Court of Protection work through the management of significant funds. And I think it's a really important area that we all try and get on top of more. We have a specialist team here in Chambers. One of the beauties of our merger means that we can offer a specialist Court of Protection. And one other point on one of the cases Amelia was discussing about Tyndall. I practice in local authority negligence liabilities arising out of childcare. And of course, Tyndall has to be read in the context of HXA, which Eddie Folks and Paul Stagg appeared in, which I think was a little less clear on how the law is settled. And we all have to remember when discussing liability of local authorities in particular in relation to child protection, they are very fact specific. So when I'm advising on these cases, I'm acutely aware that whilst the law may be settled, applying the facts to that law is often very, very difficult indeed. That's just an observation that struck me when I was listening to Amelia's fantastic update. So let's crack on with some Court of Protection now, Andrew, please. So look, I have tried to identify a couple of cases from the court that cross over civil jurisdictions and the Court of Protection. One case is a purist Court of Protection case, and the other two relate to Court of Protection issues. So if we crack on with the first slide. The reason I picked this case, this is an interesting case on its own facts, but I am advising on a case where, as a defendant, we are the recipient of a claim for a claim for costs relating to the harvesting of sperm or gametes from a brain-injured teenager. So I thought this was an interesting case because it shows the sort of steps that the Court of Protection would take. I wonder, shall I stop for HP raising your hand?
Yes.
Why not? Yeah, let's do that. Someone's raised their hand. I don't know if they want to
put something in
the
chat, maybe, I think.
Yeah. Anyway, while I'm waiting for that, I'll carry on with this case. So the reason this might be relevant is that occasionally one sees these in damages claims in particularly brain-injured younger males, and this is how the Court of Protection dealt with this case. It was terribly sad. Perfectly fit young man was playing sport and had a very severe stroke and was rendered entirely unconscious. The parents applied to the Court of Protection in an out-of-hours service, so that simply means it was done outside of court hours, because the prognosis of this catastrophically injured chap was very poor indeed, and he was going to die shortly, or certainly there was a risk of him dying very shortly. And it was a family. This was their only son, and the son had always been very vocal about his want to have children with his long-term partner. Now, what the judge says is this. The judge had to balance what was in P, so the protected party's best interests, and whether or not he, through his parents, had applied within the relevant guidance issued by the relevant authority. The OS who was instructed to represent the interests of P was this chap's wishes were, and the court said this in rejecting the application: there was no evidence before the court to persuade the court that X would have wished for his sperm to be collected and stored in his present circumstances. I cannot accept that there should be a default position that sperm should be collected and stored in such circumstances as being generally in a best person's interest. Declarations, if made, would lead to a significant interference with his Article 8 rights, and I am not persuaded that the interference would be necessary or proportionate. So at the nub of this case, there was a pushback against an assumption that a young male who had vocalized his desires to have children in his life with a relatively stable and long-term partner is simply not synonymous with a blanket acceptance that that was in his best interest. The court looked at what was in his best interest under the Mental Capacity Act and came to this conclusion. So, to bring it back to civil proceedings, if one is faced with an application or a claim in damages as a defendant for this sort of head of loss, it is eminently arguable that the Court of Protection would not order this in any event. So a useful little practice pointer on this case. Next slide, please. So Martin and Salford, that shows the importance of the interreaction between Court of Protection and civil proceedings. This was originally an application for periodical payments. There was a chance of deterioration in the claimant's physical and mental health, and mental health not meaning mental illness, but the ability to function and have capacity. The court was satisfied that there was a chance that the claimant would deteriorate in future, the claimant having capacity at the point of the hearing to at least conduct litigation, and that her deterioration might mean she would need a period of institutionalization. The court was also asked to determine whether it was appropriate for the claimant to be awarded the costs and damages arising from the need to protect that claimant if, at one stage vulnerable, they would be liable to exploitation with a large award. Now, this is a case that in the early trying to think what you call them, the early noughties, I suppose, got some judicial attention. And there are a number of cases, for example, Owen and Brown in 2002, AB in Royal Devon, and A versus Powis, where the court frequently limited recovery or refused recovery for any potential Court of Protection costs where there was a risk of future deterioration, but that risk was not present at the time of the settlement. And this case rejected the application for the costs to establish a personal injury trust on the basis that there may be a future deterioration. And to that extent, it was entirely consistent with the previous cases that I've just described. This is, to a Court of Protection practitioner, quite frustrating because it doesn't fit very well with the protective jurisdiction that the Court of Protection has over those who lack capacity but may also be vulnerable at the fringes of capacity. The court in Martin was at pains to say that the civil court has no protective jurisdiction. Another interesting point arising out of this case is that it didn't cite a case of Anthony Edis in Sol and Nove, where he left the door open, in my view, to dependent capacity costs being able to be recovered against the defendant. This was simply not mentioned. But in any way, Martin is the current statement of the law that says recovering costs arising out of establishing a personal injury trust or indeed some other form of protective measure that the Court of Protection would approve, the circumstances in which a claimant can do that are extremely limited. And so as a defendant, you will use this case to say, sorry, claimant, you cannot have it. And as a claimant, you will be worrying about how on earth you argue around this current statement of the law. And just turning to the finance and buyers, this is a neat, small little case that shows the importance of obtaining and thinking about expert evidence on Court of Protection costs as early as you can in proceedings, certainly as a claimant. In this case, it was a procedural appeal from a master. And basically what happened, there was a large claim for Court of Protection costs of over £2 million. The claimant sought further expert evidence in the form of an expert deputy to advise the court on what the future costs would be. The master said, well, you've already got a deputy, claimant, and I'm not going to go to the disproportionate expense of allowing you and the defendant to get an expert evidence to comment on future deputyship costs that your deputy can tell me about anyway, and then gave the defendant their own permission to obtain an expert on deputyship costs to rebut whatever the claimant's deputy said. Claimant appealed to the High Court, and Mr. Justice Sewell said that this was clearly the wrong outcome. Either there should have been no order for any further expert evidence on this point. So if that were the case, the claimant would have advanced the case on the basis of what her deputy was saying about what those costs would be, and the defendant would simply have to challenge those in the usual way. The alternative, and the alternative correct outcome for the master, would have been to allow them both to have expert evidence, because of course the evidence of the existing deputy would carry less weight in the court's eyes, as the High Court said, than an independently instructed single joint expert to comment on those costs. So really that is a little nugget that shows the importance of considering, even when there's a deputy in place in respect of a claimant and you are claiming substantial future deputyship costs, that you need to get on top of a decision to get your expert evidence in early. That's it from me.
Thank you very much. There's one more, but I think I've run out of time.
Hinduja and Hinduja, this is a long running bit of litigation. The only point I want to bring out of this was decided, I think, a couple of weeks ago in the Court of Appeal. It was in relation to reporting restrictions in the Court of Protection. But there's an interesting point from the earlier Chancery Division case, and it says this, and I've repeated it at the bottom of the slide. When discussing paragraph 2.2 of the practice direction to part 21, it says this, the court said this, that requires the grounds of a belief of a lack of capacity to be stated, and if that belief is based on medical opinion, for any relevant document to be attached. So if you have a belief based on an opinion, you have to attach the opinion that you base that belief on. Then Miss Justice Fold said this, so the practice direction provides that medical evidence of a lack of capacity must be attached only if A, it is the basis of the belief, and B, exists in documentary form. It does not require a document to be created for that purpose. So the final point on this is that it's only if you're relying on an opinion in respect of a lack of capacity that you need to provide that opinion. There are some cases, as was in Hinduja, where the lack of capacity was so self-evident that there was no medical evidence supporting that conclusion. So that really is it from me.
Thank you. Now, over to Esther.
Fantastic. Thanks, everybody. Lovely to see some of you, but I can see that I think there's about 80 of you online. So thank you very much for joining us. I've got the task of giving the ClinNeg update. I've got 10 minutes, slightly less than that now, perhaps. So I'm going to make a start. I'm not going to be able to deal with all of the cases that are on the slides. Andrew, could I go on to the next slide? Lovely. So you'll see I've put quite a few cases on there, all worth having a look at, but I'm just going to touch on a few of them. I'm going to start with Paul. Obviously, significant case, just sneaks into 2022, Court of Appeal's decision in January of this year. Also significant, of course, for Chambers, because Laura Johnson, Casey acted for the claimants. The basic facts, it's a secondary victim. Could I go on to the next slide, please? Lovely. Secondary victim case, basic facts of each of the three cases, and there are three linked cases. Paul is one, Polmere and the Royal Cornwall Hospital NHS Trust was the second, and the third was the case of Purchase and Ahmed. In each case, the defendants are alleged to have failed to diagnose the primary victim's life-threatening condition, and sometime later, the primary victim suffered a traumatic death. Two of the cases, Paul and Polmere, the shocking death occurred in the presence of the close relatives, causing them to suffer fairly obvious and significant psychiatric injury. In the case of Purchase, the close relative came upon the primary victim immediately after her death, and again suffered a psychiatric injury, and that was the mother in that case. The key question in each of the appeals was whether or not there was the necessary legal proximity between the defendant and the close relative, where there was a gap in time between the negligent treatment and the horrifying event of the injury. And obviously, in ClinNeg cases, it's very common for there to be a gap between misdiagnosis and the death or serious injury sometime later. But as the Court of Appeal explored in Paul, it's not just limited to ClinNeg cases. They talked about in that case the case of a negligent architect who designed a door in a load-bearing wall that some years later collapses and falls on the primary victim's head, and there's a secondary victim arising out of that potentially. So it's not limited to the ClinNeg sphere, but obviously it has significant implications in ClinNeg cases. And it's clear from the Court of Appeal's judgment that they are unhappy with the state of the law. In effect, they held that they were bound by the case of Novo, which is Taylor and A. Novo, Court of Appeal Authority from 2013. And Sir Geoffrey Voss says that it was binding authority for the proposition: no claim can be brought in respect of a psychiatric injury caused by a separate horrific event removed in time from the original negligence, accident, or first horrific event. But, he says, I accept there's no logical reason for these rules. They are the way Mr. Justice Old in Somerset and the Court of Appeal in Novo built upon the 5 elements from Alcock and adapted them to the clinical negligence context. And he says this, he says, if I was starting with a clean sheet, I can quite see why secondary victims in these cases ought to be seen to be sufficiently proximate to defendants to be allowed to recover damages for the psychiatric injury. Since, however, this court is bound by Novo, it's for the Supreme Court to decide whether to depart from the law as stated by Lord Dyson in that case. And the view was echoed by Lord Justice Underhill, and he says, if the point were free from authority, I would be minded to hold that on the pleaded fact, the claims in all of 3 cases should be entitled to recover. I do not think that recognising the necessary proximity in such cases would be contrary to the thus and no further approach taken in the case of White. It would not involve going beyond the elements established in Alcock. Rather, it would represent their application in a different factual situation. And he says, my strong provisional view, like Master of the Rolls, Sir Justice Geoffrey Voss, is that the issues raised by the merit consideration by the Supreme Court. And the case is now going to the Supreme Court. It's listed for 3 days in May 2023, and they're going to have a 7-justice panel as they're going to look at Alcock. So case to watch, obviously. Could I have the next slide, please, Andrew? I've lumped 3 cases together. I'm not going to talk about Trailer. Safe to say, another Deka case, Edward Bishop KC and Susanna Bennett for the successful defendant in that case, and I'm not going to talk about Williams. I am, however, going to talk about the Lewis Ranwell G4S case. Another Deka case, in this one, Gurian Tausig and Andrew Warnock Casey for different defendants. Very sad case. Claimant was mentally unwell. He went on to kill 3 people, 3 elderly gentlemen in their own homes. The claimant then brought a claim in negligence against the defendant health providers, arguing that their treatment of him had given rise to circumstances in which he'd gone on to to kill those people. 3 defendants were a health services company, an NHS trust, and a local authority. And the criminal matter, the criminal case went to trial, and the claimant, defendant in the criminal trial, was acquitted of murder and manslaughter. He was found to be insane. The McNaughton applied, and he was detained in hospital. And as I say, he sought damages from the defendants for personal injury, loss of liberty, reputation, and dignity. And all 3 defendants applied pretty forcefully to strike out his claim. And their submission in a nutshell was his claim should be struck out as it was founded on the consequences of his killing of 3 people. And according to the defence of illegality, a claim could not succeed if it's founded on the claimant's illegal or immoral act. And matter came before Mr. Justice Garnham. And he says, well, the defendants can show that the time of the death of the 3 men was a result, show that the death of the 3 men was a result of the deliberate acts of the claimant. That's pretty obvious. But he said it's not sufficient to exclude liability that the immediate cause of the damage was the deliberate act of the claimant. The defendants must point to an act of knowing wrongfulness, was the phrase he used. This must mean they must be able to show that the claimant was guilty of a criminal or quasi-criminal act that engaged a public interest, and they've failed to do so. And he explained it in this way. He said, promoting legal consistency and avoiding legal incoherence are underlying objectives of the illegality policy. There would be legal incoherence between the criminal law and the law of tort if a claimant could found a claim on his own criminal or quasi-criminal act. But he says there's nothing incoherent in permitting a claim founded on a third party's negligence if that negligence was a substantial cause of injury or loss, and the claimant's insanity meant no blameworthiness attached to him. as is the case here. And so the court therefore finds that in order to succeed in striking out the claim on the grounds of illegality, the defendant had to establish the claimant knew that his actions were wrong. And defendants had failed to establish criminality or quasi-criminality on the claimant's part. And there's an appeal to come on this one, so it may not be the final word, but it's an interesting case and it's well worth a read. I've got a bit more time. I'm going to talk. Could I go on to the next slide, please? I'm going to talk about Hughes and Rattan in brief terms. This is a dental negligence case. Claimant's position was that she had received negligent dental treatment from 3 dentists on various occasions between 2009 and 2015, and the defendant was the owner and operator of the dental practice where the claimant had attended for her treatment. But she wasn't treated by the defendant. She was treated by 3 separate dentists and 3 associate dentists and 1 trainee. It later transpired who was an employee in the practice was vicariously liable for them. First instance, the court found for the claimant both in relation to non-delegable duty and also in relation to vicarious liability. On non-delegable duties, the judge found the criteria in Woodward and Swimming Teachers Association was satisfied, and on the vicarious liability position, first instance again, concluded the treating dentists were providing treatments as an integral part of the practice and found for the claimant on that as well. Defendant appealed. Lord Justice Bean gives a leading judgment and found on non-delegable duty, the judge had correctly found that the defendant was under a non-delegable duty of care to the patient. She was in law a patient of his practice, and the judge had correctly satisfied all of the Woodland factors, and the Woodland criteria were explained, but they didn't need to go on and consider vicarious liability. But if they had, they would have found that the Barclays test wasn't met for a number of reasons, the most important of those being that the treating dentists were free to work at the practice for as many or a few hours as they wanted to, and free to work for other practices and businesses. So Cox was considered, Barclays was followed, and although they didn't need to decide it, had they done so, they would have concluded the defendant wasn't vicariously liable for the treating dentist. So again, key decision from the year. I'm going to talk, I've got a couple of minutes perhaps. Could I go on to the next slide? Just going to touch on Pickering very quickly. Andrew, have I got time? Just a minute or so? Yeah, good. All right. Pickering, just worth touching on. First instance case, Mr. Justice Ritchie, High Court case. It's all about a stroke and about the timings of provision of low molecular weight heparin, and the facts aren't. We don't need to trouble ourselves. We haven't got time for it, but we can it's worth looking at just for expert evidence and just in terms of how the experts came across at trial. And it really is a really important case about looking at making sure you've got experts who are going to stand up to scrutiny if you get to trial. This was a case where Mr. Justice Ritchie was very critical of both of the defendant's experts and one of the claimant's experts. And it's really important, critically important, you have well-prepared experts who are able to conduct a detailed analysis of the medical literature and able to deploy it correctly. One of the experts had misquoted an article that they were seeking to rely upon. So you need good and reliable experts who are going to perform well in court. Of course, it's the case, very few clin-neg cases get to trial, but it's always worth making sure at the outset you have experts who are going to do well at trial should the need arise. You don't want another advocate for your case. But you do want somebody who's well prepared, who's read all the relevant literature, make sure they can remember it and use it correctly, but also who are careful and balanced in their views and able to explain their position to non-medics, i.e. judges, and are able to justify their position in the face of challenge. And if in doubt, discuss choices with counsel, because this is, as this case demonstrates, if it goes wrong, it can go pretty catastrophically wrong. There's one more case on the slides. I'm not going to touch on it. I think I'm out of time, but happy to deal with any questions.
Thanks very much, Esther. Well, I'm now going to talk about some travel law updates, and I'm going to be talking about 4 different topics, starting with the vexed question of Spanish penalty interest. Well, the question of what interest rate to apply can be of critical importance in cases governed by Spanish law. And the reason for that is that there is a rule in Spain that provides for penalty interest at a rate as high as 20% after 2 years from the accident or event in various circumstances. So it's always going to be very strongly in the claimant's interest to have these Spanish rules be followed when a Spanish law case is taking place in the jurisdiction. But then conversely, it's of paramount importance for the defendants trying to reduce the claim to avoid the imposition of these really very high and punitive interest rates. And courts have grappled with how to deal with this on a number of occasions, notably the 2 conflicting cases of Scales and Troke, where High Court judges reached different decisions. Well, this has been considered at least twice this year, notably in the case of Sedgwick and Mapfre, a case of Matt Chapman cases from this chambers. Well, Mrs. Justice Lambert, who was the judge, followed the decision in Troke. She considered that Troke couldn't be distinguished and held then that the question of the penalty interest was a matter of procedural law and not substantive law. And the significance of that being that as procedural law, it was a question for the forum, whereas if it was substantive, it would be a question of the applicable law, which is Spanish law in this case. So Mrs. Justice Lambert followed the Troke decision and endorsed the reasoning in Troke. She considered that the penalty interest provisos were in the nature of procedural sanction to give teeth to the procedural aim to encourage early settlement or early payments in cases, and noted that it wasn't part of full compensation because it's nothing to do with losses suffered by the claimant, and rather this is a penalty to penalise the defendant for not making payments more quickly. And she held that the correct analysis of these were discretionary provisions that can be excluded if there's good reason to do so, and a procedural, as I've said. And that meant that interest in that case was governed by Section 35A of the Senior Courts Act, because it was procedural, so as a matter for the forum. And this, of course, gives the judge a discretion about what interest rate to apply. And the judge considered that it was perfectly clear that if this case were being heard in Spain, then the Spanish interest rate would apply. And the judge considered that her role was to attempt to arrive at a figure which equated to that which would be awarded by the foreign court. And on that basis, the judge awarded the Spanish penalty interest rate as a matter of her discretion under Section 35A of the Senior Courts Act. And I should say, the argument was raised by the defendant that this would actually be a sort of double jeopardy, because there's a similar sort of provision in our procedural rules with Part 36. And the defendant said that if you award the Spanish penalty interest, then there's potentially going to be a double lot of penalties payable by the defendant if they fall foul of Part 36 as well. And the judge rejected that argument, saying that that Part 36 wasn't automatic and the Part 36 consequences could be supplied if appropriate, and it might well be unjust to have a situation where you have this double jeopardy actually emerging, but that of itself was not a reason why the court should fail to award the Spanish rate as a matter of its discretion. And that's the same result that was reached in a very similar case heard in Norwich by Her Honour Judge Walden Smith, again a Matthew Chapman case. And again, in that case, it was exactly the same result. The judge applied troque, holding that the question of interest was procedural, not substantive, but then went on to apply the Spanish interest rate as a matter of the discretion under, in that case, Section 69 of the County Courts Act. So that's where we are at the moment with Spanish penalty interest, but we certainly haven't seen the end of it and expect more cases on that in the year ahead. Now, moving on to my next slide, because this is a festive update, I thought what could be more festive than some basic philosophy? And on that question, I'm going to pose two philosophical questions. What is an accident? And related question, what is an injury? Well, I'm not being facetious. These are questions that were indeed considered by the CJEU this year in the context of the Montreal Convention. And so far as the Montreal Convention is concerned, we all thought we knew what is an accident and what is an injury, but it turns out that the CJEU thinks otherwise. Now, the first of these cases I'm going to talk about is the JR case at the bottom of the slide there. And this is the case about what is an accident. Well, what happened here is that the unfortunate claimant slipped and fell while walking down some steps on her way out from an aircraft. And no reason at all was identified for why she slipped. There wasn't any defect found with the steps, and there wasn't any foreign body or slip hazard actually on the steps at all. So according to the fact-finding court, this was a slip that happened for no identifiable reason. Now, was this or was this not an accident? Well, before this decision, everyone would answer saying, well, this isn't an accident. And the reason for that is, well, I had quite a long legal pedigree, and going back to Air France and Sachs in 1985. And that is because to be an accident, the courts have held on a number of occasions that there needs to be something unusual or unexpected which is external to the passenger. And it's really the external to the passenger bit that's so significant here, because if you have a fall without any identifiable external cause, then that requirement isn't fulfilled. And this is why the Advocate General, in his opinion, held that this case did not make out an accident for the purposes of the Montreal Convention. But the CJEU disagreed, and they held that essentially the fact of the fall was sufficient to constitute an accident. They considered that the concept of accident should be given its ordinary meaning. And I'm sure we'd all agree that somebody slipping as they're going down some steps is an accident in layman's terms. They considered that it was an unforeseen, harmful and involuntary event. And they held that the concept does not require any connection between the accident and the operation of the aircraft. And the basis for that part of the decision was relying on an earlier CJEU case, GN and ZU. And in that case, the CJEU held that whatever happened didn't have to be anything to do with the operation of an aircraft. But it is quite a different case because GN concerned somebody spilling coffee. So there absolutely was an external event there. It wasn't, as happened in this case, an accident without any identified external cause. The second argument from the CJEU was that this is a system of qualified strict liability, and there is a defence set out in the Convention under Article 20. This is essentially a contributory negligence provision, and it does enable a defendant to defend the claim completely, essentially with a finding of 100% contributory negligence. And the CJEU considered this was sufficient to strike a balance between claimants and defendants under the Montreal Convention. The problem with this, though, I think, is that whether will it really work as a defence in a case like this? If you have somebody having an accident without any identifiable external cause, is that really going to be a case for 100% contributory negligence? If you have no external cause, then that would include no fault on the part of the victim. And we've had a question here in the chat about that. I'll be interested to know what people think, and if we've got time at the end, I'll come back to that. The other case I'd like to talk about is what is an injury. And here we have a pretty unbelievable case. A flight from London to Vienna. We have one engine exploding during takeoff. This meant that passengers had to embark via the emergency exit. While the claimant was disembarking, the other engine exploded, causing her to be hurled several meters through the air. And perhaps surprisingly, she sustained no physical injury at all, but was subsequently diagnosed with post-traumatic stress disorder as a result of this incident. The claimant sought damages under Article 17 of the Montreal Convention, and this was denied by the defendant on the basis that bodily injury doesn't cover pure psychiatric or psychological injury. And that, again, had been held to be the case in many jurisdictions, including this one, in a case from the Supreme Court called King and Bristow, although that was interpreting the similarly worded Warsaw Convention rather than the Montreal Convention. And the CJEU's reasoning to allow a claim for a pure psychological injury was that bodily injury must be given an autonomous European law interpretation, unshackled to the approach adopted by individual member states before. They referred to Article 31 on the Vienna Convention, saying that treaty terms must be interpreted in good faith and in accordance with their ordinary meaning. And the CJEU considered that bodily injury doesn't include pure psychological injury, but adopted this on the basis that in some signatory states, psychological injury is recoverable under certain conditions, and that the case law for recoverability will develop over time. They went on to say that the whole scheme is supposed to protect the interests of passengers, and noting that a psychological injury can be as severe for its consequences for a person as a physical injury, that it would be wrong not to permit recovery for pure psychological injury. Now, rather oddly, having widened the ambit for what is covered by bodily injury, the court went on to then try and rein in the floodgates. And there's quite a curious wording that they've given, saying that damages are recoverable only if the aggrieved passenger demonstrates to the requisite standard that they've had, but they have to show it by means of a medical report and proof of medical treatment, the existence of an adverse effect on his or her psychological integrity of such gravity or intensity such that it affects his or her general state of health, particularly in view of its psychosomatic effects, and that it cannot be resolved without medical treatment. Well, that raises an awful lot of questions. What sort of medical treatment is sufficient? When is a psychological injury sufficiently grave or intense to affect a general person's health? What are psychosomatic effects? It really raises, seems to me, more questions than it answers. I think really this is a reflection of the fact that the Montreal Convention is out of date, the fact that it hasn't traditionally been interpreted to include psychological injury, or indeed take any account of equality laws. And it might seem right to lots of people that you should be able to recover for that sort of thing. But if so, probably would be better for the convention itself to be amended rather than for it to be corrected by judicial creativity. Well, I'm going to move on to my next slide, and I think I'm running out of time here, so I'm going to have to accelerate. But my next slide is about, again, rather a festive spirit, considering claims when you've got a tour operator or other defendant who's got bus, and where the alternative claim under Section 75 of the Consumer Credit Act's in play. Well, If you've paid for a holiday or any service with a credit card, as well as having a claim against the main defendant, there is a like claim against the credit card company. And I say there's a like claim. It's the debtor who has a like claim. And this has given rise to lively debate about who actually is the debtor. Is this anybody who benefits from the holiday contract? So including children, for example, who won't have paid for the holiday, or is it limited to the card holder? Well, we now have the answer from the Court of Appeal. It is only the contractual debtor, which is to say only a party to the credit agreement, who is able to bring a claim under Section 75. If you have a child who didn't pay for the holiday, tough. The only person who can claim under the Consumer Credit Act is the contractual debtor. And the final thing I was going to talk about is the standard of proof and whether that's procedural or substantive. And this is from one of my cases. And this situation can arise because if you're dealing with a case with a foreign applicable law, it's possible that the standard of proof is different under that foreign applicable law than here. Now, the case of Marshall and MIB has held that the standard of proof is procedural and therefore a matter for the forum. But of course, you might have a situation where that means you get a different answer if a case is decided here than in the foreign court. In my case, the proof that was required in the jurisdiction of Switzerland was much stronger, strict proof than the balance of probabilities that would be required here. And in my case, the judge left open the door to the possibility that in an appropriate case, you could apply the strict proof or the law in the law of the tort rather than the law of the forum. And that is if, to specifically make out a particular defence, part of that is a different standard of proof than that applies under the general law. Now, in my case, the strict proof was the general law, and that was the general law that applied to this particular issue. But if a particular aspect requires proof to a particular standard as a matter of substantive law, then we may find that that's held to be substantive rather than procedural. I'm conscious that I've gone on too long, so I'm going to hand over at this stage to our final speaker.
Hello, can everyone hear me? Thank you very much to my colleagues for leaving me 2 minutes to give this presentation. It's much appreciated. It's the kind of teamwork we like. Yes, personal injury. Next slide, please. I may have slightly run over, but I will do this as quickly as I can. I used to be a school teacher in my early 20s, and teaching the lesson just before lunch was always a complete nightmare. And here I am again, many years later, trying to keep you away from your toast or whatever you have lined up for lunch. I'm going to look very quickly at some duty of care issues, and we started with Tyndall. We're going to end with HXA, which is an interesting case to read alongside Tyndall, as Ed already flagged, and then some other quick case law updates. We've already talked about Paul, so we can leave that. Next slide, please. We're going to start with HXA and YXA. We have a Christmas theme today, which really, apart from the festive jumpers, has gone nowhere. We have some X's finally here to try and crowbar in a Christmas theme, but apart from that, it's going to be the usual diet of abuse and fatality due to freak accidents that's going to follow. We've got HXA, which is a case to do with children being subjected to severe abuse and neglect by families. But what we're trying to do as claimant lawyers in this case is establish a legal relationship between a local authority who is not a corporate parent with parental responsibility on these facts and children who've been abused by third parties, i.e. not the local authority, of course. We're trying to establish a nexus and a duty of care to then argue that it's been breached. So it's an assumption of responsibility argument that the social services have come into the life of these children and therefore created a duty of care that is actionable. Next slide, please. What we find in HXA and YXA is that these claims have been struck out just on the basis of the pleadings. Until the Court of Appeal got involved, and this is another Deka Chambers case, the Court of Appeal have allowed the appeal, and they have said that there is a potential assumption of responsibility here. They look at Section 20 of the Children Act. Those of you who don't practice in family law, family public law, will want to know that Section 20 is about a local authority providing accommodation for any child in need, broadly speaking, who requires it due to the parents not being able to provide accommodation, or due to perhaps a child being abandoned, those sorts of situations. So the issue is, can you have an assumption responsibility argument there? Well, obviously, I think in terms of providing accommodation itself, you've got to weigh in under the statute anyway. But here the argument was actually returning children out of the accommodation back into the care of parents who are known to be abusive. The argument is that could potentially create a duty of care, which seems difficult, but the argument was made, and the Court of Appeal have allowed it to go forward. Next slide, please. Lord Justice Baker here saying this is a very fact-specific situation. You need a case-by-case basis, and you can't lay down guidance in a judgment like this for all cases that are so widely fact-specific. And if you think about the ways in which social services can come into the life of a child and potentially intervene, try and keep them safe, you can see that there are many ways, various ways in which liability could be created, and how different factual scenarios could appear. But that does stand in stark tension, I think, with Tyndall, which Amelia started with, which is a case which says actually we can strike out this case because the law on public authorities and when they can be held to owe a duty of care is actually settled. It's not in flux. Well, the Court of Appeal and HXA take a different view. They see it very much as in flux and developing. And one way you might try and explain those two authorities from the Court of Appeal is that Tyndall actually wasn't a very strong case. It's based on a police car arriving on a situation where a motorist is injured due to black ice, and they put the motorist into an ambulance to look because he's injured. So the argument that by doing that, they've stopped that motorist from keeping other road users safe, I think is a stretch, to put it mildly. And it's obviously a one-off isolated incident as well. It's not like it's a situation that's been known about for a long time. So I think Tyndall perhaps on its facts. Next slide, please. So where we are with HXA is that it's developing law. It's not particularly clear when a duty of care could be owed, and therefore further strikeout applications in this area will probably fail at the moment. But the defendants want to go to the Supreme Court to appeal it, and that will be a Chambers case. And it will be interesting to see what the Supreme Court do with this, because they may want to lay down some policy points here that they don't want a flood of claims against social services. And following COVID, I can tell you, as someone who also practices in family public law, that area has really exploded following lockdowns, where a lot of families with abuse going on within them were locked down by the government. And it was very, very difficult for a lot of social services to get into properties to see what was going on because of the restrictions. And there may be a lot more to come. I've certainly seen some horrible cases, and you would have read on the news the kinds of things that have gone on during lockdown and involving child cruelty. So there may be a lot to be said more on this case, and it's going to be, I'm sure, heard by the Supreme Court. Next slide, please. A very quick look at vicarious liability. It's always an interesting case, area of law to look at. It's been in the Supreme Court many times. This was an interesting one where you've got workers working for different employers on site. And a lot of this case was on the basis that the Rolltech site fitters were in competition with the tarmac cement site fitters. And what happened is that there's a tarmac employee who plays a practical joke on the claimant by setting off a pellet in his ear and causing him acoustic shock, and whether you can make the tarmac fitters employer vicariously liable for what had happened. Next slide, please. The Court of Appeal say no, you can't this is a good example of when you're trying to appeal something, when there have been very detailed findings of fact by the lower court, you can get really stuck because you can't really get around those findings. And here, the Court of Appeal felt that the findings made at first instance made the appeal necessarily fatal. Next slide, please. It's an interesting sort of case study for vicarious liability. It's a reminder of how fact-specific those issues are. But the key points here was that the equipment used to cause injury to the claimant was not workplace equipment. It was something that had been brought in as a joke by the other employee. It was a horseplay case, so it was a practical joke. They were mucking around. It wasn't anything to do with work they were authorised to do. They were mucking around during, I think, the lunch break. There was no supervisory role from one employee to the other. There was no hierarchy. They were both on the same level. And what happened, the way the joke was played out, was nothing to do with the business of the tarmac fitting business. It was just a background or a context to what had happened. And on the idea there was some kind of tensions between the two sets of workers, the Court of Appeal rejected that on the facts and said, therefore, it wasn't reasonably foreseeable that this was going to happen. Nobody knew that this practical joke was going to be played. So no liability, dismissed. Next slide, please. Brown is an occupier's liability case. It's a woman who drives around a very sharp bend in Cornwall. She loses control of the car and she goes through a pretty hopeless, non-existent fence into a reservoir where she tragically drowns. The argument was that this was extremely dangerous. You've got a reservoir on a sharp bend, and you've got no fence, no proper warnings, nothing there to tell you that this is potentially a fatal situation, and therefore the claimant sues as occupiers the people who occupy the reservoir along with the council. Next slide, please. There was an attempt here to distinguish Tomlinson and Congleton, which is about somebody, you might remember, key case on the 1984 Act, somebody who dives into a lake as a trespasser despite a warning sign saying don't do that, and suffers horrific injuries as a result. But the argument was that in Tomlinson, the trespasser knows what he's doing, whereas here this was totally involuntary, and essentially it was completely sort of a passive victim of a very dangerous situation, unlike Tomlinson, where you knowingly take a risk. Next slide, please. It's dismissed because the Court of Appeals say this isn't a danger due to the state of the premises. It's not due to the state of the reservoir that this accident happened. And there's no duty if you border a highway to stop someone coming off the highway onto your land. You can't possibly have a duty to do that. Next slide, please. So that claim is dismissed. Pool, we've talked about already, and it's just important for personal injury lawyers as well to be aware of what happens next year in Pool. Next slide, please. And finally, in Hoyle, this is just a very short High Court judgment, just to really, for all you local authority lawyers out there, this is a superbly defended claim. It's a tree that falls onto a car and kills someone tragically, but the inspection regime was good and more than adequate, and the expert evidence was clear in the court's view that it wasn't obvious to any reasonably competent tree inspector that this tree was going to fall over at any point. Next slide, please. And you have a court as well not wanting local authorities to be unnecessarily removing trees and destroying habitats because of a concern of legal liability. And that's a Section 1 Compensation Act 2006 point, which is often worth remembering, to slip that in here. And also, obviously in this area of law, as always with personal injury, thinking about what do we want the law to be doing in terms of making people safe versus how far is the law going? Is it overreaching and making everything into a compensation culture and actually destroying the ability of local authorities to get on with their jobs in an unimpeded way? And that, I think, will be at the heart of the HXA appeal, which we will hear more about next year and may well feature in this in these slides this time next year. Thank you very much. Happy Christmas, everybody. Go and have some lunch. Thanks for listening.
Well, thank you very much, John, and thanks to everybody for attending today. I'm sorry we've overrun. I think, although it says on the questions, I actually don't think we have time for any, and I think we all need to head off. But if people do have questions, then please do email us. We'd love to hear from you, and we're very happy to consider questions over email. So once again, thank you so much for coming. Very Merry Christmas and lovely holidays to everybody. And yes, we'll see you all in the new year, if not before. Thank you. Bye-bye.